E565 of 2024.
My lords, may I request, with your kind permission, if we could allocate time so that we structure the presentation, and for our part, on the part of the respondents, we will respond together, and whatever time you will allocate to us, we will use together.
For our part, my lord, because we have to do the job of convincing the court, I believe we agree on the first application and the one to deal with it. I will need 30 minutes to present my application.
You need how much?
30 minutes.
My lord,
yes, my lord, I say that's speaking for myself. I believe there are other people who speak for themselves.
my lord, with your kind permission, for record purposes, I wish to bring to the attention of the court that we shall no longer be acting for the sixth respondent in this matter, and to that effect we have filed a notice to cease acting on account of the Supreme Court decision that determined that the president cannot be subject to civil proceedings. So in that regard, we will not be able to act contrary to an express court order, and we have therefore filed a notice to cease acting, and we ask the court to deem that to be a sufficient notice that the person named as the sixth respondent is now unrepresented in these proceedings.
Thank you, Dr. Kamotho. However, we are not inclined to do anything this afternoon except the business of the two files before the court. After that, we can take directions as may be necessary.
Most obliged.
As far as time allocation is concerned, this is how we'll allocate time. The main applicants will give you 15 minutes each. The main applicants, we will give you 15 minutes each. Supporters of the application, we will give you 5 minutes each. If you are supporting the application, we'll give you 5 minutes each. Respondents will give you 7 minutes each. Interested parties will give you 5 minutes each. Rejoinder by main applicants will be 7 minutes each. We ask the court assistant to observe time strictly.
Can you permit me to say something? This is our first impeachment case since we became an impeachment cases are mixed up with all sorts of things like law, politics, security of the country, and etc. My very humble suggestion is that, so far as possible, let people say what they want to say. It's a healing process. And coming up with 5 minutes, 10 minutes, 7 minutes, my lord, it does damage not only to ourselves, but to the entire nation. It is a nation we are concerned about, all of us. When chips are down, the number just advocates take different positions when you have a matter before the court. But when it comes to impeachment cases, we are all concerned about the safety of the state, to save the states. Let people say what they want to say. There should be no impeachment. That's my view. And may I say to you most respectfully, I am coming to this matter on behalf of the people of Syria. We stand for the rule of law, the supremacy, and for preservation of the state of Kenya. Let people say what they want to say. let us not come up with 5 minutes, 10 minutes, or 20 minutes and so on.
My Lord, Your Ladyship, I appreciate the matter before this court is the recusal of the judges. But please, I urge you to be a little bit more flexible on the issue of time, particularly 5 minutes. My Lord, no council enjoys making an application for recusal of judges. It's a very weighty matter. So please, allow us a little bit more flexibility.
Dr. Kamuna has submitted that he needs unlimited time, meaning that he can argue this case even until tomorrow. Mr. Mwite, how much time do you require for yourself?
I would say for those supporting at least 10 to 15 minutes. It's just relaxation that I'm asking for, so that the issues are wholly articulated.
My Lord, may I suggest that we stick to the time you have allocated us, and you have the discretion to allow anybody, including my learned senior, the Honorable P.K. Moite, any flexibility.
I think that's what we did last time. We allocated times, but we were flexible enough to add time whenever it became necessary. So with those submissions in mind, we'll give you the time allocations which we have given, but with the latitude to grant more should it be necessary.
I was going to request that because we are prosecuting this application, that we just say that officially so that I don't feel pressure. I have 30 minutes. This is a kind of case, my Lord, that if you do not argue it, inevitably, this case can somehow happen. I don't want anybody to accuse me I did not argue this or the other when I had an opportunity. 30 minutes will not bring heavens down. It is only 15 minutes to enable me to do the job, not for myself.
Yes, my Lord, here we go again. Here we go again, my Lord.
Let me speak. This is a court of law. I respect you very much, counsel, senior counsel, and all the counsel here. But please let us appreciate that this is a court of law. And when directions are made, please let's respect those directions. I'm making this direction. We have allocated time. Should it become necessary for one party to ask for more time, we will consider that. Thank you.
My Lord, the first application in which we have filed these documents in the file officially called petition number E015 of 2024 is an application dated 21st of October 2024. It is supported by an affidavit that has been sworn by this affidavit has been sworn by the Honorable David Muni Madenge. It is further supported by a supplementary affidavit that is 21st, a supplementary affidavit of 24th of October 2024 by the Honorable David Madenge. My Lord, in addition to that, we have filed a bundle of authorities which I believe that they have been furnished to the court. My Lord, looking at my watch, it is 3 p.m. I am certainly going to require some additional time, but let me start and see how best we can manage the time that has been allocated. My Lord, in a ruling that you delivered yesterday, you made a significant point that this is a matter of extreme weight issue that can be conducted both with regard to the office that it relates to and to the issue of political succession. My Lord, the issue of political succession countrywide is an existential issue of the state. Existential issue of the state in the sense that this is an issue that when you read Professor Ben Nabweze, and when you read all these cases from Pakistan, they are the most weighty constitutional issues that can appear before any group of judges. And my lord, for purposes of this country, we are saying that for the 2010 constitution, the matter before you, and that is why has informed the filing of this application, is one that is an existential issue for purposes of the 2010 constitution. Your Lordships, I say
Your
that...
Honor, sorry for interruption. You have been muted. I am unable to follow proceedings. Okay. Now it's okay.
Yes, my lord. So I was submitting and saying that it is an existential issue for two reasons, my lord. My lord, most of us who are at least practicing for 20 years are aware of two provisions of the former constitutions of Kenya. We used to have a section 23 of the Kenyan constitutions in which all executive powers were vested in the president. That position radically changed under the 2010 constitution. We used to have section 30 of the constitution in which parliament meant the president and the legislature. My lord, those positions changed. The change of those positions, which is the submissions that we are making, the impeachment proceedings would have the consequences, if it goes the way in which it has gone, of effectively bringing back to life sections 23 and sections 30 of the former constitutions. Now, the second issue that I need to emphasize on the existential issues of the constitution is this. My lord, from the standpoint of the constitutions, and to safeguard constitution, there is these issues that is called security of tenure that certain offices enjoys, particularly with regard to the questions of removal. My lord, the two offices that enjoys the greatest tenure are the office of the president and the office of the deputy president. My lord, why is that the case? Because they are legally protected that to remove a president or a deputy president, you need impeachment. They are also secured by the electoral process, that those two people, to get to those offices, they must be voted into those offices by the people. But the significance of this is this. Every other holder of the offices, from constitutional office holders to judges and everybody else, doesn't enjoy political tenure. It is only legal protection for those particular offices. So that, my lord, the point is this, that the true weight of this matter is this. If it were to turn out that an office that enjoys the greatest protection, like the office of the deputy president, can be called, the removal can happen as we are alleging it happened in this case. My lord, the whole scheme of constitutional tenure and the protection that is necessary to protect our democracy would effectively be null and void. This would mean if you have numbers, you do not like the speaker of the day, you can get him out. Numbers in a democracy, and that is why you write the constitutions, numbers must be controlled by law. If we reach a position where numbers cease to be controlled by the law, my lord, that would effectively have negated all the constitutional gains that this country has made. My lord, having made that point of the nature of the issues that you are dealing with, let me come to the issues before you. My lord, the petitioners, or in those cases, in those affidavits, in the applications, are saying a fairly simple issue. They are saying that as a result of events that occurred in Kirinyaga, that are partly the subject of the yesterday's decision that was made, and as a result of other matters that is the subject of the supplementary affidavit, the petitioners feel, and the petitioners are of a strong opinion, that a case of this magnitude is not the kind of case that should be decided by a bench in which they do not enjoy full confidence in. My Lord, the basis of that, since this is highlighting, would be four. My Lord, on the first issue is that the petitioners, and in their applications that they did and is a subject of overruling, they pointed out certain issues that brought into question the issues of the transparency, the proper accountability for purposes of the handling of that particular file. The affidavit is there. And they, according to the petitioner, that brought into them some doubts, the manner in which the handling was done, as to the impartiality of this particular bench. The petitioners goes on to issues number 2. They said that whereas they put in an affidavit setting out the reasons why there was a problem in the manner in which those issues were done, the respondents did not respond to challenge those particular set of facts. But my lords, the petitioners are saying that now that the respondents did not challenge their set of facts, the contrary issue that happened is this, that in the ruling that was read yesterday, we got a copy 30 minutes ago, there was a section that was called Other Issues. In the section that was called Other Issues, the petitioners are saying that this court answered factual and evidential issues that relates to that application. And the consequences of that is that although they had been agreed, to them that would amount to this court entering the arena of conflict between the parties, the petitioners and the respondents. And my lord, the old principle applies that a judge, one cannot be a judge of his own cause, and in any matter that they are dealing with, it should be a matter that they are absolutely neutral as far as the facts and the evidence are concerned. My lord, in our African societies, I've talked to my parents, I talked to Mr. Ogata, he said his community had the same set of issues. According to my community that I came from, in any those cases that used to be done traditionally, the first thing that would arise was this, and Article 159 says we respect our customs. It was to ask those who will be able to determine this case, are all the parties satisfied with this group of wazes that will be deciding the case? If either of the parties say,
my community does not do that.
I don't know about yours. I say mine and Okada. Mine is
Okada is mine.
I don't know. Okada will talk for himself. But let me have some peace. I think he wants to destroy my train of thought. So that the point I was saying, I can be happy. Okada can defend himself what he told me. But my Lord, I'm saying, at least for my community, that issue would arise. Does any of you have a problem with any of these wazes who will decide the issue? My Lord, if the issue arose that a party says, I don't want that wazee to be there or that other one, invariably, and this is communal justice, that person would pull out and get another mzee that everybody feels comfortable with. So that, my Lord, and I've appeared with you, I respect all of you absolutely. The petitioners are saying the circumstances of this matter is that we are unable to enjoy that confidence. My Lord, when the petitioners were speaking about what they said they feel, like is a 3-judge bench, one in which they expect fair and square justice. That was a terminology in the case of Gelongori that we have attached on our submission. That from the word go, a party appearing before the judges should be able to feel that we have a reasonable chances of success between those judges, but more importantly, that none of the judges is connected to the cause, one, to the cause, or to the individual in which you are in dispute with. My lord, why is that important? That, my lord, is important because since Saturday of this week, in fact up to yesterday, but the petitioner says they have been treated